Good morning. This is your Kelso Report for Wednesday, July 18th, and I'm your host, Clark Kelso. Glad to have you with us. We begin with a search and seizure case out of the Ninth Circuit Court of Appeals. The defendant in United States v. Pope pled guilty to misdemeanor possession of marijuana and reserved his right to appeal the district court's denial of his motion to suppress. A police officer made two separate commands directing the defendant to empty his pockets. The defendant refused the first request, so that command did not result in any intrusion, according to the Ninth Circuit. In other words, the Fourth Amendment was not violated by the mere command to empty one's pockets. The subject actually has to empty his or her pockets for there to be an unconstitutional intrusion. As for the second command, according to the Ninth Circuit, it was supported by probable cause, and because exigent circumstances justified searching the defendant without a warrant. The probable cause existed because, after the defendant refused to empty his pockets in response to the first command, the officer asked the defendant, who smelled of marijuana, whether he had any marijuana on him. And the defendant admitted he had been smoking and did in fact have marijuana on his person. Exigent circumstances existed because it was highly likely the evidence would be destroyed if the officer did not immediately undertake the search. Next, we have a case involving the Fourth Amendment. In Patel versus City of Los Angeles, a split panel of the Ninth Circuit upheld the constitutionality of a provision of the Los Angeles Municipal Code, which requires operators of hotels in the city to maintain certain guest registry information and to make that information available to police officers on request. A hotel operator contended that the provision was facially unconstitutional under the Fourth Amendment because it authorized unreasonable invasions of their private business records without a warrant or pursuant to any recognized warrant exception. Following a bench trial on stipulated evidence, the district court held that the ordinance was reasonable and granted judgment in favor of the city, concluding that the hotel operators did not establish that they had a privacy interest in the guest registry information. As for the Ninth Circuit, noting that a facial challenge is the most difficult challenge to mount successfully, since the challenger must establish that no set of circumstances exist under which the act would be valid, the Ninth Circuit rejected the plaintiff's claim, finding that the plaintiff had not introduced any evidence at all establishing that it treated the hotel registry information as private. The majority was careful to note that it was not holding that a hotel owner or operator can never have a reasonable expectation of privacy in guest register information. And it rejected the argument of the city that hotel owners can never have a reasonable expectation of privacy in the guest registries, simply because the regulation informs them that the police can inspect the registries on request. As the majority explained, an individual's otherwise reasonable expectation of privacy cannot be so easily stripped away merely by the adoption of a regulation authorizing searches of an item or location. So, although the statute is constitutional on its face, it's quite clear that further litigation will arise under this ordinance, or can arise under this ordinance, in particular cases. Hotel operators, though, will have to come forward with evidence that they treat the information as confidential and private in order to establish a constitutional violation. Next, we have a big victory for the United States Bureau of Reclamation in National Resources Defense Council versus Salazar, where the Ninth Circuit, by a split panel, upheld the renewal of 41 water supply contracts that are part of the Central Valley Project against an environmental claim that the renewals threaten the existence of the Delta smelt, which I'm sure we all know is an endangered species. For many of the contracts, the court held the plaintiffs lacked standing because the contracts contain a shortage provision that allows the Bureau to take any action to meet other legal obligations, which include not delivering water if it actually does threaten injury to the Delta smelt. Given this clause, the court reasoned, any threatened injury to the smelt would not be traceable to the contract renewals, so the plaintiffs are not able to allege a causal connection between the challenged action by the Bureau, contract renewals, and the alleged injury. For the remainder of the contracts, the Bureau essentially had no discretion because the contracts were the result of a settlement of prior litigation, and the contracts required renewal for the same quantity of water. As you can see, a big victory for the Bureau there. Next, we turn to a land use decision from the California Court of Appeal in Goldstone versus County of Santa Cruz, where the 6th District approved the County Board of Supervisors' rejection of an application to convert a mobile home park from rental to condominium ownership based on the near unanimous opposition of the mobile home park residents as reflected in a survey of resident support. The owner, who applied for the conversion, argued that Section 66427.5 of the Government Code limited the grounds for evaluating the application for conversion to whether the applicant had complied with the statute's requirements, and that considering the survey results was inappropriate. The 6th District disagreed, holding that the board properly considered the survey results under subdivision D5 of Section 66427.5. The court noted that while it is true that language in subdivision E limits the board to assessing compliance with the requirements of the statute, subdivision D5 expressly requires that the survey be conducted and submitted to the board, quote, to be considered, close quote, as part of the hearing. Given this language, the board properly considered the survey results in denying the application for conversion. That's it for today's Kelso Report. Have a great day in the law.